Welcome to our video on media law, focusing on intellectual property. This video project is made and presented by Group A.
In this video, we will explore copyright law in Malaysia. We will cover the definition of copyright, the legal framework, the duration of copyright, ownership, and transfer of copyright, a key case study, and the specifics of copyright infringement under Malaysian law.
Copyright is the exclusive right given by law for a certain term of year to an author, composer, etc. to print, publish, and sell copies of their original work. It applies to expression of an idea, not the idea itself, and protection is automatic once the work is created and fixed in a tangible form.
The Malaysian Copyright Act 1987 is the primary legislation governing copyright in Malaysia. It outlines the rights of copyright owners and the protection of original works, including literary, musical and artistic works, films, sound recordings, and broadcasts.
Copyright protection in Malaysia lasts for the life of the author, plus 50 years for literary, musical, and artistic works. For films, sound recordings, and performances, protection lasts for 50 years from the date of publication or performance.
Copyright initially belongs to the author. However, there are exceptions such as works created under a contract of service or employment. Copyright can be transferred through assignment or licensing, which must be in writing.
In the landmark case University of London Press Limited against University Tutorial Press 1916, the court dealt with the copyright of examination papers. The University of London had exam papers created by appointed examiners and then assigned the copyrights to University of London Press for publication. The court ruled that these examination papers were indeed protected by copyright, emphasizing that copyright applies to original work that demonstrate sufficient skill and effort. This case underscores the importance of recognizing copyright in educational materials.
Section 36, subsection 1 of the Malaysian Copyright Act outlines what constitutes copyright infringement. According to this section, it is an infringement to perform any act controlled by copyright without the owner's permission. This includes copying, distributing, and displaying the work publicly. For example, making and selling copies of a book without the author's consent is an infringement. This law ensures that creators' rights are protected and unauthorized use is prevented.
Section 36, subsection 2 of the Malaysian Copyright Act provides further details on what actions are considered copyright infringement. It includes activities such as selling, renting, distributing, and publicly exhibiting the copyrighted work without authorization. This section aims to prevent commercial exploitation of copyrighted materials without proper licensing. For instance, renting out copies of a movie without the right holder's permission will be an infringement under this section. These provisions help maintain the integrity of copyright protection by addressing both commercial and non-commercial violations.
In conclusion, understanding copyright law is crucial for protecting intellectual property rights. The Malaysian Copyright Act 1987 provides a legal framework for copyright protection. Thank you for watching, and we hope this video has been informative.